Good afternoon. There's almost 6.5 hours of argument time requested, so only ask for the time that you need, not that the time you wish. If we have further questions, we will keep asking them. Justice Higgett is on the screen over there, and will be participating in oral argument remotely. People versus Panigua is submitted. Francis versus Lambert, appellant. How much time are you requesting? Respondent? Okay, the respondent is not here. We often submit in that circumstance, but since you're self-represented, we will let you have 3 minutes of time, okay? Crystal is submitted. Jackson versus Consolidated Edison, appellant. Okay, that is submitted. Cantor Fitzgerald versus PEI, appellant. Respondent? I'll give you 6-1 and 6. Again, if we have further questions, we'll keep asking. People versus Megget, appellant. That is submitted. Nobody's recovered from Thanksgiving yet. Silver Linings Interiors versus RN Symbia, appellant.
2 and 6, Your Honor.
I'm sorry, what?
2 for argument, 6 for rebuttal.
2 for argument and 6 for rebuttal?
I'll reserve 6.
Respondent?
15 minutes, Your Honor.
I will give you 3 and 3, and I will give you 6. Wells Fargo versus Hayden, appellant. That is submitted. Batista Rosa versus 1230 Franklin, appellant. Respondent? 4, 2, and 6. Ronald versus Taisha is submitted. People versus Cuevas, appellant. That is submitted. People versus Rosavong, submitted. Pocock versus Nocel Realties will be submitted. New York State Division of Human Rights versus Dawn Homes Management, appellant. Respondent? I'll give you 5, 1, and 5, and again, if we have more questions, we'll keep asking. Earl versus City of New York, and I know there are 2 appellants in this case.
Brown the appellant, 5 and 1, please.
4 and 2. 4, 2, 4, 2, and 4. People versus Rodriguez. 6, 1, and 6. Thompson versus Thompson. Is only one side here? I'm here to respond, Your Honor. Is anyone here for appellant? Do you wish to submit? I'll give you 3 minutes, and if we have more questions, we will keep asking. And that is the end of the call of the calendar. So the first case is Francis versus Lambert.
How much time do I have, Your Honors?
3 minutes.
3 minutes total.
Yes.
Good afternoon, Your Honors. May it please the Court. My name is Lisa Aptaker. I am the appellant in this case and the daughter of Ms. Julia Lambert, also known as Julia Aptaker, an interested party as well and cross-petitioner of the lower court, New York Supreme Court guardianship case 500-746-2023. Your Honors, I'm here today respectfully asking you to reverse the decision made by the Supreme Court, which is the subject of the appeal, due to the fact that petitioner failed to provide the statutorily mandated clear and convincing evidence that my mother is incapacitated. Petitioner failed to meet the statutorily mandated burden of proof to have made this decision. The evidence and the record, especially in her own words, as you have read, Your Honors, in the supplemental record, shows that my mother, Ms. Julia Lambert, also known as Julia Aptaker, had a plan for the management of her person and property, management of her affairs, and possessed sufficient resources to protect her well-being, thus obviating the need for a guardian of her person and property. The first point I want to make very quickly, I hope I have enough time, is that there's no doubt that I am an aggrieved party within the means of CPLR 5511, and I once again established that I have standing to pursue this appeal. I have a three-pronged argument. The first one is the statutory standard wasn't met. As per Mental Hygiene Law 81.12, it places the burden on the petitioner requiring proof of, by clear and convincing evidence, which wasn't done in this case. Mental Hygiene Law 81.02 defines incapacity narrowly, that the person must be likely to suffer harm, and this was also not proven. There was no evidence presented. The record shows that my mother's testimony was credible. There were no functional or any other assessments that were presented. She has undergone, Your Honors, severe limitation of her civil liberties. I speak before you today not only as a daughter and a mother, but also as a very experienced physician myself for over 30 years with additional experience in health policy and management. I've never seen such a gross error, with respectfully I say, as an injustice as has been brought upon my elderly mother, who has no cognitive problems or diagnoses. I haven't seen my own mother, and no one has, for over 2 years. Her grandchildren, who are sitting here today, have lived through this tragedy. It has been a tragedy for 2 years. I just cannot say how much we have suffered as a family. As you know, Thanksgiving has just gone by. My mother has been alone, a fully cognitively and intact person who has falsely been imprisoned. I speak to you today, Your Honors, from the heart, that not only is this unlawful, but very sad for our family and others who aren't even related to us who have heard this story. I refer you to the supplemental record, a letter written by my mother and sent to Judge Tingling on October 4th, shortly before the final guardianship order was entered, pleading with her to reverse.
You have 2 more minutes, even though.
2 more minutes?
Yeah.
Okay, thank you. The case, Your Honors, is so egregious that after expressing my concerns to Administrative Justice Adam Silvera, Judge Lisa Sokoloff was forced to recuse herself from this case. Subsequently, several judges have refused to be appointed to this case and recused themselves as well, including Judge Michelle Sweeting and Judge Alana Marcus. I'm asking, Your Honors, that you reverse the incorrect decision made by the Supreme Court, which is the subject of this appeal. In sum, the petitioner failed to meet the statutory burden under Article 81. The record contains no clear and convincing evidence of incapacity, no competent medical testimony, and no functional assessment. The trial court's order rests on speculation and violates both statutory and constitutional mandates. I respectfully, Your Honors, request that this court reverse the guardianship and dismiss the petition. I am an aggrieved party as defined under CPLR 5511. To uphold this guardianship, Your Honors, would set a dangerous precedent, allowing liberty to be curtailed based on conjecture rather than on truth. Your Honors, just as I took the Hippocratic Oath over 3 decades ago, I am respectfully asking that you uphold your judicial oath to administer justice fairly and impartially and reverse the lower court's unlawful decision to declare my mother incapacitated when she has no cognitive issues whatsoever, and appoint a guardian of her person and property without the requisite statutory requirements of petitioner meeting its burden of proof. Thank you, and I reserve the remainder of my time to answer your questions. I do want to emphasize that whether there has been any unconventional issues that the petitioner had mentioned, for example, that my mother didn't bring a key to the hospital, my mother and I have lived together most of my adult life along with her grandchildren, and I was expecting to pick her up from the hospital and bring her home. This is not the definition of incapacity, Your Honors. Thank you for your time.
Thank you. The next case is Cantor Fitzgerald versus PEI. Return.
Good afternoon, Your Honors, and may it please the Court. Cantor Fitzgerald brings this appeal because res judicata cannot apply when the affiliates of the defendant engage in a legal shell game to evade liability. That's exactly what happened here. Defendant PEI Holdings' FINRA-regulated affiliates evaded FINRA's jurisdiction effectively by taking banking work from Cantor Fitzgerald, transacting that business through an unlicensed LLC that could not be forced to arbitrate.
Could you address the issue before us, though, which is the issue of whether or not there's privity between the people or entities that were before the arbitration and those who are not, and why there isn't privity, which would make it a binding determination?
So, Your Honor, there is no privity because the case law indicates that ownership and control of an entity is not sufficient to establish privity when that entity's rights and liabilities were not conclusively resolved in the prior arbitration. As we can see from the Saratoga case from the Third Department, the Bravo case from the Second Department, and the Blue Sky case from the Second Department, in all of those cases, there was ownership and control of one of the entities by a party to the prior arbitration. But in each of these cases, the department concluded that privity did not apply because the record from the first proceeding did not establish that the second defendant's liability had been conclusively established. And that's exactly the case here. The arbitration award says nothing about PEI Holdings' liability. In fact, there is not even a place in the record where the respondents asserted that PEI Holdings was not liable. There is no cite to that in the opposition's brief. Instead, their argument was that PEI Holdings is the only entity that can be held liable for the business torts. For example, they stated that it would be weird to go after a few individual bankers when there is truly a real business behind it, a business that's not accounted for in this hearing. That's record at page 760. Similarly, with respect to the PEI broker-dealer, they said that the engagements between PEI and the former Cantor clients during the non-compete period we looked at were between the clients and PEI Holdings.
Let me ask you something. They do make those references, but they really don't have any reasoned decision for us to look at. But don't we have to focus on the very specific legal issue of whether there is or is not privity between these two parties, since that is the law, that if there is privity, then it's binding. So can you specifically address, based on the relationship between these two parties, why there's not privity?
So, Justice Curran, the reason that there is no privity is because, as this court held in Rojas, privity requires that the interests of the non-party were represented in the earlier litigation such that it had a vicarious stay in court. And what the Court of Appeals held in the Buchel case was that on a question of res judicata, any doubts should be resolved against imposing preclusion to ensure that the party to be bound can be considered to have had a full and fair opportunity to litigate.
But here, it's undisputed that the individual bankers who were in the arbitration, our defendant's principal, hold 100% of its equity, and that all the arbitration respondents were aligned with defendant by a common purpose, were represented by the same counsel in the arbitration as defendant is here. So doesn't that satisfy the traditional notion of privity?
It does not, Your Honor, because the question is whether they specifically put PEI Holdings' own liability front and center, not simply whether PEI Holdings could have been held vicariously liable for some of the torts alleged against the individuals. The case that
What's the case that holds that?
The Blue Sky versus Jerry self-storage case from the Second Department is the most on point. In that case, the defendant in the second case was an LLC that was owned and operated by 3 individual defendants in the first action. The same claims were brought against the LLC in the second action, and the Second Department found that res judicata and privity did not apply because the defendant did not establish that the issues of fact and questions of law relating to its alleged liability were necessarily decided in the prior matter. And over here, the award does not reflect at all that PEI Holdings' liability was ever decided. Rather, the defense from the respondents was that if any entity is liable, it's only PEI Holdings. It can't be a broker-dealer, which did not compete during the non-compete period, and it can't be a few bankers when there is a much bigger business behind it that involves lots of other people who also competed, also serviced Cantor's clients, and also may have had interactions that can be imputed to PEI Holdings. The last point I'd like to make is that is that the fact that this second case stems from the same transaction occurrence is not dispositive, and the Supreme Court erred by ending its analysis there. As we've seen in the Avalon, Saratoga, and Blue Sky cases, the second action involved claims that were identical to claims asserted in the first action. And in Avalon and Saratoga, in fact, the exact same damages. But res judicata did not apply because the record from the first proceeding did not establish that the non-parties' potential rights and liabilities were resolved. And that's exactly the case here. Now, we've gone through a few of those citations in the record, and the last thing we urge, Your Honor, is that if there is any doubt about what the record means, all of those inferences should be resolved in favor of Cantor Fitzgerald. Because as this court said in Frank versus Solomon, in determining a motion to dismiss based on res judicata, a court must credit a plaintiff's allegations raising the inference that the prior action was not intended to encompass the instant claims.
Counsel, if I may, what, if any, consideration should this court give to the fact that, the bankers and PEI, they're in the same industry, the same attorney who represented the respondent in the arbitration represents them in this, appeal. And once again, the bankers own and operate PEI. So, what, if any, consideration should we give regarding these factors?
Justice Kennedy, what we would assert is that fact should cut in favor of Cantor Fitzgerald because they intentionally executed a strategy in which they pointed to the empty chair. That was their own decision, the same attorney who is now representing them here. And in fact, the Shays Will case that respondents rely on in their brief shows that when you make a statement in the first proceeding as to whether that party is represented and whether the non-party's interest will be decided, that representation stops you. And we'd say that applies here. They took the position that PEI Holdings was not in the room and therefore was not vicariously represented.
Thank you.
Good afternoon, Your Honors. Joshua Liston of Liston LLP for the respondent, PEI Global. As was noted, I was also counsel for the individual bankers in the arbitration below. It's good to see my good colleagues on the other side who litigated that arbitration on behalf of PEI. I'm sorry, on behalf of Cantor Fitzgerald. Frankly, I don't think we need to litigate again because, as the court below correctly found, res judicata applies clearly.
What about the potential problem, though, that this particular respondent was not before the arbitration and that they never got an opportunity to argue on the merits, the liability of this particular respondent who had different arguments could be made against this respondent that could not be made against people who were present at the arbitration?
Well, respectfully, I don't think there is a single argument that they could make against PEI, the entity that they didn't make against the individual bankers. And I know that because they made every single possible argument against the PEI bankers in the hopes that they would bring in the conduct, not just the hopes, that they actually did bring in the conduct of PEI Holdings, the current defendant. How do I know that? Sorry.
But during the arbitration, it was one of the witnesses said, well, that is not the entity, the entity is not here. So meaning that there must have been a claim that either affected or did not affect the entity that is the respondent now. So isn't there something, doesn't that tell us something that perhaps not all the claims would go to this specific respondent?
Respectfully, no. Let me explain the one comment that they've taken from the closing statement, kind of ignoring everything else that was said. So there was an issue with respect to the damages at issue in the case, okay? They pointed to, and this kind of proves my point, they looked at PEI Holdings, the defendant in this case, all of its revenue for the period in question and said all of that is attributable to the individual bankers. For the clients that they allegedly took from Cantor, we pointed out that there were other clients that didn't come from Cantor that went into that overall amount, and that Cantor had never tried to identify only that revenue at PEI Holdings that was attributable to the PEI bankers individually. And we also made a comment when they were seeking to hold PEI broker-dealer, a different entity that was a respondent in the FINRA arbitration, responsible for certain engagements that PEI broker-dealer wasn't part of. We said in that case, you can't look to PEI, the broker-dealer, you have to look at PEI Holdings. But we never denied. In fact, every party, I mean, it's clear in the papers, operated under the assumption, not the assumption, the truth that the individual bankers and PEI Holdings were indistinguishable. We never said that if you find something that PEI Holdings did wrong, that you can't hold the individual bankers responsible. And in fact,
Let me ask a question.
Sure.
One of the claims was tortious interference with prospective business relations with clients.
yep.
How could the court have decided that issue in the arbitration proceeding where they were not a party to the arbitration? And the specific claim is that that entity interfered with prospective relations with clients.
There's a couple responses. The most direct response is that they did seek to hold the individual bankers responsible for PEI Holdings conduct. And you don't have to take my word for it.
Right, but they didn't get a chance to argue whether or not PEI should have been held liable for PEI's conduct. Because PEI wasn't there.
PEI Holdings conduct was at issue. And I know that because in their complaint in this case, in its record 26, paragraph 22, they say PEI, through the actions of its 4 members, immediately took steps to wrest the U.S. Power Group's pending deals and other business assets away from Cantor. That was what we litigated. That is what we litigated. And they had PEI emails, they had PEI's principals up on the stand, they had PEI engagement letters, and they used PEI Holdings revenues as the basis for their damages calculation. We did this case. And I'll point out that it was a month before the hearing started that Cantor amended its claims to say, now that we have all of this stuff from PEI Holdings, we're amending our claims against the individual bankers to hold them responsible for PEI Holdings conduct. And that's what happened in the arbitration. The arbitrators obviously awarded a certain sum of money with respect to the unpaid loans, but the rest, they said all the other claims are denied. That's a final decision on the merits. It's between a party that there is privy with in this case, and frankly, they actually didn't appeal whether the claims between the 2 cases are any different. That's effectively conceded. It's just the identity of the parties, and a clear case of
All of defendants' interests were represented in the arbitration, even if right now they're not all members of FINRA. They are not part of that arbitration agreement.
So all of the individuals were named respondents and participated in the FINRA arbitration below. PEI Holdings, the defendant here, is not a member of FINRA. We think they actually probably could have brought us in, but put that aside. It doesn't matter whether PEI Holdings could have been brought in as a party. What matters is if there's privity between the 2 parties. And Shays Will, TPR, Hament, these cases make clear that there is. We did this case already, and they walked away with millions of dollars. Arbitrators denied them the exorbitant amounts that they were seeking from the clients based on PEI Holdings revenue. Thank you very much.
Thank you, Your Honors. 3 very quick points. Number 1, I believe Mr. Liston made a reference to our statement in our complaint in the arbitration. The reference to PEI there is obviously to the PEI broker-dealer, not to PEI Holdings. It did not become clear that PEI Holdings was effectively an unlicensed investment bank until very shortly before the hearing. Number 2, Mr. Liston seems to spend a lot of time arguing that we asserted the same claims in the previous case. And what I'd like to reiterate is that is not the standard. The standard is whether PEI Holdings' actual liability was put front and center and whether that was adjudicated.
So the only issue before us is whether or not there was privity.
Yes, and privity.
That's the only issue that we have before us. Either there was or there wasn't privity between these 2.
Exactly. And the Avalon, the Bravo, the Saratoga, and the Blue Sky cases make clear that privity does not apply when you point to the empty chair. The argument that they would have needed to make is that PEI Holdings is not liable because none of its agents are liable. What they said is actually PEI Holdings is the only entity that could be liable, and that defeats finding privity.
Thank you very much. Silver Lining Interiors? Go ahead.
My apologies. Good afternoon, Your Honor. Adam Oppenheim on behalf of Joel Arancibia and Arancibia Construction, the appellants in this case. On October 21st, this court ruled that the restrictive covenant at issue today was unenforceable. There's no difference in fact or law since that time, October 21st, compelling a different result. Nearly every argument.
So you're arguing that the decision issued by our court is dispositive as to the issue of whether or not there's a valid covenant not to compete?
Yes, Your Honor. And I believe that all the issues raised in respondents' papers can be answered by reference to that decision. So in an effort to distinguish the facts of today's case, Silver Lining points to only one thing, and it makes no sense. What they say is that the agreement that this court is considering today is different because Silver Lining subsequently waived a requirement that Arancibia provide a release of all his claims. Okay?
But our decision wasn't based on that at all.
That's correct, Your Honor. But the decision does say the following. What it says is, and it's the last line of the decision. I do have it. I guess I'll have to rely on my papers for this, Your Honor. I'm sorry. The last paragraph of the decision on October 21st says that it makes no difference whether or not it was waived because Arancibia, as it says in the decision, Arancibia received severance payments, and Silver Lining did not, at the time, ask for a waiver or a release. And so, effectively, there's no difference in the facts now than they were before. And that was in this court's decision.
Qualifications as to our finding that the non-compete was unenforceable, right?
Well, the finding of the...
We didn't have any qualifications on our determination.
That is correct, Your Honor, and it's actually a little bit more than that. The first thing the court said in the first three paragraphs of the October 21st decision is the agreement's unenforceable. And the last thing the court said, this court, in its fourth paragraph was it wouldn't even matter if there had been a waiver of the release requirement because those things effectively already happened. The money was sent, no waiver was ever provided. So that doesn't make a difference. And here we are litigating the exact same thing. It's the exact same question. Nothing else has changed.
Okay, so let's find out from the other side why they think we shouldn't follow our own decision.
Thank you, Your Honor. I reserve the balance of my time. And I'm sorry about the, I made a little spill.
Ah, okay.
No history in the record. Sorry about that.
May it please the court. Leslie Corwin, I represent the respondent, Silver Lining Interior.
Okay, so why isn't our decision dispositive now that the covenant not to compete is unenforceable?
Your Honor, this court's October 21st decision and order has no preclusive effect on this appeal.
Why not?
And there's, if you'll let me.
Can't wait to hear why.
I'm gonna go through it, and if you'll indulge me, I'm gonna take you through it and tell you, I hope, and why it does not. Have to understand is that these preliminary injunction orders were issued at a time when the appeal that was argued that resulted in the October 21st decision and order was sub judice. They had been sub judice for over 5 months. 2 members of this panel were on that panel where Mr. Oppenheim and I argued before. It was always clear, and this is where I think there was confusion, and I can clear it up for you because the trial court did, and it's in the record before you. During that period of time, it was always the understanding, starting from the trial court who issued the decision, that there was a 6-month non-compete in effect. And that was while this appeal, the first appeal, was sub judice. When it came to the attention of Silver Lining, and while this first appeal was sub judice, we, at the invitation of the trial court, went back to the trial court on July 10th.
I'm sorry, is your argument focused right now on the issue that we should enforce a 6-month covenant not to compete? Is that what you're
Yes,
arguing right
because
now?
if I can, and if
Given up on the 3 years and you're now arguing the 6 months? I want to be
what
clear.
I'm trying to say that all that was before and all that was intended to be before the Appellate Division First Department, as clarified in this record that's before you now.
That
was
doesn't,
whether
that's not apparent
that
from,
I'm sorry, Justice.
that's not apparent from the face of the decision we issued, which doesn't have any qualifications.
Well, the decision.
It just says the covenant to compete is not.
With all due
You're not,
respect.
counsel, you have to let me finish asking
Go ahead, Justice Kern.
the question. Our decision says without any qualification that the covenant to compete is not enforceable, and in fact noted that although plaintiff received severance payments despite not executing release, there was no basis to enforce the otherwise unenforceable non-compete. So our decision was broad. It covered the main argument you're arguing why the non-compete shouldn't apply, and we didn't have any qualification, we didn't have any discussion about it applying for 6 months. Why shouldn't that be the law of the case?
Because I do not believe that I think that the court was incorrect in its decision. I think that
Basically, are you arguing that we should overrule ourselves? Is that your argument?
as a matter of law, I think it was wrong. And if I just can, if you'll just indulge
It should be
me.
the argument you make to the Court of Appeals then.
Well, I'd rather not go, but anyway, Judge, it's an important case for this court, and I think we understand that. If you'll just indulge me for a moment, and I'm going to pages 312 to 314 on the record of appeal, on this record on appeal, and I think you'll understand where I'm coming from. You may not agree with me, but I just want this, I want to clear before this court, and then I'm happy to go into the last part of the court's decision. But if you go to page 312, and this was one. This is the judge, and I'm at line 3. The court. The extent that you think that Mr. Aaron Sibier is acting in bad faith, you should look to expand the record in front of the appellate division to demonstrate to them. And that goes to line 6. Then later on, and this is Mr. Oppenheim speaking, and we're at line 18. As I believe, the court consistently noted in January, even without the requirement of release, the restraints in the underlying employment agreement are too broad to be enforced as written. The court. I did not say that. I did not say that as anything like that. I said they weren't enforceable solely by virtue of, and if there was an errant word in the discussion, we essentially discussed this at the prior hearing. That was a hearing on July 10th. Please, I admonished both of you about going to the appellate division on a ground that I did not rule on. Maybe I should have issued a supplemental order. I'm sorry, it was sub judice with the appellate division. He's referring to the appeal, that was the prior appeal. And the holding of the case, as I pointed out at the last hearing, you and Mr. Corwin, was simply that you couldn't condition compensation, and this is the key.
I understand that that's the appeal that's before us right now.
That's correct.
That's what he said, okay.
Further compensation or already earned compensation on the execution, and this is the key thing. This only had to do with the execution of a general release. And then when he goes on,
I
he goes
understand
on
he
page
disagreed
3.
with he disagreed with what he earlier held. I understand that. That's the appeal we have before us. He did not agree. He said he was wrong the first time, And so that our appeal should then be wrong. Is that your argument?
Look, that's part of the argument, and he basically, he says, I know that something, I'm not mad, I know that something was raised with the appellate division about duration, and I didn't intend for the dicta in the decision that should have been filed to what I found offending under New York law.
Counsel,
Now,
we understand your argument that he didn't mean his first decision, so we shouldn't consider our appeal decision.
All it had to do with was the general release. As far as the, and I know you've
Thank
read
you.
our briefs and we've done it. As far as whether this is enforceable and unenforceable under New York law and dictated and case law that goes back over a quarter century to BDO Seidman v. Hirschberg, this is not unreasonable what's here.
Thank you. Thank you, counsel.
Just 1 second. Oh, I'm sorry. In the January order, the trial court absolutely did not say that there is a 6-month restrictive covenant in place. That is just not what that decision says. What it says is the following. I don't have that one in front of me, but I've recited it back and forth with my client enough to be able to tell you without looking. It says that the restrictive covenant is unenforceable beyond the 6 months in which Aaron Sibio would receive compensation, and is entirely unenforceable because it requires the release. Now, this court has already undone that decision. There were problems with it, and that's fine. That's not what I'm here to talk about. I'm only correcting the statement that those words put in place a 6-month restrictive covenant. They did not. And that actually becomes problematic for respondents if what they want to say here is that they should be credited with having waived the requirement of a release back in January. They didn't. They didn't do it until July when Justice Borak asked them to. There was a period of time before this case got before Justice Borak when this restrictive covenant was inarguably in place. No one said we waived the requirement at that time, and that's when it mattered. We can't undo that history. That order in January said what it said, whether Justice Borak regrets it or whether it makes a point. It said the restrictive covenant is entirely unenforceable, and there was no effort to waive anything. This is a cynical effort to get around that ruling. It's not fair. My client should get his opportunity to work. He's been waiting a year. Thank you very much for your time.
Thank you. Batista Rosa versus 1230 Franklin.
May it please the court, Nick Serlin from McMahon, Martini, and Gallagher for the appellants 1230 Franklin LLC and Angel Development, Inc. The sole issue before this court is regarding Labor Law 240 that the court below granted to the plaintiff, and the decision was based upon the language or from other case law saying that the permanent staircase where the plaintiff fell was the sole means of access to in the building where the incident occurred. Obviously, that's not the standard for Labor Law 240. The standard is whether there was a proper safety device provided for the plaintiff.
I'm sorry, though, don't we have a line of cases that do make that holding?
Not-
That a stairway can be a safety device when it's the sole means of access to get from one floor to another, and a worker is using it to carry materials from one floor to another, that in those particular circumstances, the stairs themselves can be treated as the safety device. I mean, we have cases that hold that, right?
Yes, but not permanent staircases. The cases
Some
that,
of the cases are permanent staircases, aren't they?
no, the cases that are presented by the respondent in this matter are instances where they were unfinished stairway. It was not permanently installed. The plaintiff in that incident, which was in the Ramirez.
What difference would that make? Assuming you're correct about that, what difference does it make?
Well, because
Isn't
the issue- yeah.
Isn't the principle behind these cases is that when you have to use the stairway to get from one location to another, and there's no other way to do that, and you're carrying materials on that stairway, that stairway in effect becomes a safety device.
No, it's whether the work is it's necessary the work that's being performed, meaning as if the work was going to be taking place in the stairway. It's integral to the work that's taking place. So obviously in the Ramirez one, again, there was an issue with the stairway itself, that it was defective. The plaintiff fell through it. And they were stressed in that instance that the sole means of access was because it was tied to it being an unfinished structure. They even specifically cite to the matters of Griffin versus New York City Transit Authority and Crimi Neves Association, which in both of those matters, they specifically were distinguishing between a stairway that was attached to a building versus a permanent stairway. And in that matter, they were trying to say, yes, if a worker's going to go up a ladder that's attached to a building, that's the sole means of access, and they were distinguishing.
In our case, how would you have proposed that plaintiff get to the second floor from the first floor?
Well, it's not, because that's not the standard, though, is that he was just going to another floor to get his materials. He wasn't performing any work. It wasn't integral to performing the work on the stairway, or that it was necessary for the work that was being performed. In these other cases, you see Wilde v. Broadway, that plaintiff in that matter is going up to a scaffold. He has to go to that work area to perform the work. In this matter of Conlon, the plaintiff in that matter is actually performing work in the stairwell itself.
I'm glad you brought up Conlon, because I was going there, and it just seems to me that that case seems to be controlling here. You talked about how the plaintiff in that case was required to do work, and it seems to me that the plaintiff in this case was also required to do work. I mean, here we have the plaintiff who is performing construction work in the staircase, and Conlon, like this case, involves a permanent staircase.
Well, no, in Conlon, the plaintiff in that matter was literally installing sheetrock while working in the stairwell. So essentially, they're using it as like a ladder. They're working in the project area, whereas
And
this one,
here, the plaintiff is using the stairs to bring materials, to the designated area, because that's the only means to perform the work.
but it's a passageway. Otherwise,
Really?
if we expand the scope, every time there's a single stairway in a building, we're going to hold that Labor Law 240 must be met because the plaintiff fell down the steps. That's
Because he
not the
was
standard.
carrying pieces of pipe upstairs by walking up the staircase. And he slipped on a tube that was on the landing of the staircase.
But that would go to 241, 6, and 200 as whether there's a defect there, which is a question of fact. That's why that's not for this court. That's not related to saying the stairwell itself was defective in any way. It's a permanent staircase, and there was nothing defective about the staircase itself.
Thank you.
May I proceed? Oh, Michael Prisco for the respondent. This court should affirm the lower court because a permanent staircase, when it is the sole means of access at a construction site, is a safety device. This court has held that time and time again in Ramirez, in Conlon, most recently in the Sky Doniak case, and therefore this court should affirm the lower court holding. As far as whether any of those cases were dealing with permanent stairs, they were. In Conlon, that was a permanent staircase. And most recently in 2025, the case Sky Doniak, that was a permanent structure. It was an escalator, permanent stairs. And also to the point of whether it matters or not, whether the worker is actually working in the stairway, that distinction does not matter. Although the plaintiff here absolutely was working, he had to be in this area to carry the pipes back down to the first floor. But even assuming this court has never held a distinction requiring that the permanent stairs are the sole means of access, that the accident happens while work is being performed in the stairs. And we see that again in the Sky Doniak case, because all the worker was doing there was walking up the escalator to get to where he needed to perform the work. There, the escalator
Well,
was
sir, I'm sorry to interrupt you. Certainly a permanent staircase or a temporary staircase, either one, can be a labor law 240 safety device. But what was the elevation-related hazard to which the plaintiff was subjected?
Okay, so when you're dealing with a permanent staircase at a construction site, where it is the sole means of access, it's different where it wouldn't be the sole means of access because the worker now doesn't have a choice. Here, the worker only has a choice to get to the elevation where he needs to be, up 7, 8, 10 feet. He has to use these stairs, and it's foreseeable at construction sites that there's going to be heightened risks associated with negotiating stairs, carrying materials like debris on the stairs, or here the lights off in the stairs, or the wet nature of the stairs as we saw here from the leak and the roof. And that's where the case law has developed over time. Defendant cites a case from 1983, but this court has progressed from that point in time following cases such as Runner, where we're not applying 240 in a formula, in a mathematical step-by-step formula. We're looking at the totality, what the foreseeability risks are here, and that's why this court has held and why this court should affirm the lower court that these permanent stairs were a safety device because it was the sole means of access in this case.
Thank you.
Okay.
I'm sorry, go ahead, you have more time.
I was just going to say if the court had any more questions, otherwise I'd rest on the brief.
Okay, thank you.
I just want to bring up 2 points, Your Honor. Number one, for the Skydunia case, what happened in that instance was that even though it was an escalator that was not in operation, the plaintiff fell as a result of there was some masonite that was installed onto the escalator. So it wasn't the escalator itself. There had been some work done on the escalator, and the plaintiff in that matter got stuck on some tape or some other material that was on the escalator. So it wasn't, the escalator was not just there stationary as it was in a permanent fashion. And I also want to bring the court's attention, even though it's not binding, this Norton versus Plaza Owners Corp matter, which is identical on point to this issue, where they held, the Second Department had held that a permanent staircase, that just because it's the only point of access for a worker does not mean that it's instantly a 241 matter. So I would ask the court to just consider that matter, even though it has no precedent in the First Department.
Thank you. New York State Division of Human Rights versus Dawn.
Good afternoon, Your Honors. May it please the Court. Sarah Estella on behalf of the appellant, Westchester Residential Opportunities, Inc., who I will refer to throughout argument as WRO. Left uncorrected, the lower court's decision in this case would allow a discriminatory actor to turn a choice of forum into a windfall. This outcome is not only inconsistent.
So why is it a windfall? It appears that the whole way this scheme is set up is that it gives a complainant, such as the appellant in this case, a choice. You could either go to court yourself and bring the proceeding and act as the counsel, or you can go to the New York State Division of Human Rights, and if they find probable cause, they can then go to court and proceed. But I don't see anywhere in the setup that allows both things to happen. It's an either-or situation. So why is that unfair in any way, since the choice always lies with the complainant in the first instance?
Well, there was a choice in the beginning of the case to choose our forum, and WRO chose to proceed before the Division of Human Rights. That proceeding went forth. The division found that there was probable cause to believe that discrimination had occurred.
But the
And at
statute
that,
clearly provides that once they find probable cause, that they should then commence an action on behalf of the complainant, and that they can give the complainant an opportunity to substitute their own counsel, which it doesn't appear was availed of here. And if the complainant doesn't substitute its own counsel, then the division goes forth. So everything happened, it appears, as it was intended to under the executive law. Why did anything inappropriate occur here that should be reversed?
because the option to, there is, you're right, after a probable cause hearing, the division will commence a case or the complainant can substitute. However, it doesn't mean that there's no available other option to intervene, and we didn't want to supplant the.
It's so clearly laid out exactly why the procedures are. Why should we put in a third option that's nowhere laid out in the procedure, especially when there are so many steps throughout the process where the complainant could have had the opportunity to come in and litigate themselves, but they chose not to. So why allow basically two people to come in and make the same exact arguments? The complainant already is being represented by the Division of Human Rights.
Respectfully, the complainant is not represented by the division. The Division of Human Rights attorney represents the Division of Human Rights.
On behalf
And
of
there
the
are,
complainant.
well, they're basing their complaint on the allegations and the record that was developed below, but that doesn't mean that the Division of Human Rights represents their interests. Their interests are different. The division has a broader scope. They represent people throughout the state. WRO's work is in the lower Hudson Valley. The other thing is WRO has expertise that relates to its own practice as a fair housing organization that undertakes testing, and so they could bring to the litigation those that expertise and that
Right,
nuance.
but that
And the
was
other thing-
their interest. They could have just commenced an action on their own behalf. I mean, that was an option that was available.
They could have, but there is also an option available under the CPLR, which is intervention. And we're entitled to intervention under the CPLR because our interests are not entirely aligned. And the other thing to note about that is WRO doesn't have an option to not participate in this proceeding. They are obviously an incredibly important component, and so they would be forced to participate without the representation of counsel, which we know the human rights law didn't intend because there's fee shifting. And so that also goes to the beginning of your question, Your Honor, about a windfall, which is that it cannot possibly be that a simple choice of forum between proceeding before the division and going to court will allow discriminatory actors to evade attorney's fees altogether. Because the human rights law grants attorney's fees for precisely this situation. The other reason that it would result in a windfall is because it would force a complainant to participate without counsel, and so that means that not only are their interests not represented, but they would also not have counsel to ask questions, right? If they ask a question to the Division of Human Rights attorney, that question is not covered by attorney-client privilege because the division does not represent them. So I see my time is up, and I'll reserve the remainder for rebuttal. Thanks.
Thank you.
Good afternoon, Your Honors. May it please the court, Benjamin Neidl for the respondents, Dawn Home Management. I'll try to be brief and just sort of hit some points here.
Let me ask you something. The right to intervene is very broad, particularly the permissive right. Since they clearly do have interests, or it has interests different than that from the Division of Human Rights, why shouldn't the court allow a permissive intervention?
Because of a couple of reasons, Your Honor. First, the first reason the entire scheme is set up, as you indicated, to have one or the other. Under Section 297(9), it's the complaint is presented by an attorney of the division, or with the consent of the division, the complainant can be represented by their own attorney. It's one or the other. That statute does not contemplate both. Okay, that is in contrast to the administrative hearing subdivision. If you look at 297.4 of the executive law about administrative hearings, that statute's a little more permissive, saying that the division can give permission to a private attorney to participate in the hearing. There is no corresponding language in 297.9 concerning civil actions that we're dealing with here. It's one or the other. That's what the scheme contemplates. They either be represented at no cost to them by the agency that is the expert in this field in New York State, right? Or they secure the permission of the agency to step in and take their place, which they have not done. There is no have your cake and eat it too, and that would be prejudicial. Section 1013, by permission, it is a discretionary statute in the trial court's discretion. It says in the court's discretion it must consider whether there would be prejudice to a substantial right of a party or undue delay, and there would be here. First of all, purely economically, if you want to talk about windfalls, in cases brought by the division, there is no award of attorney's fees. In cases prosecuted by private litigants, there can be an award of attorney's fees. So just by adding a second advocate to the bench, when they're already represented by the expert agency, just like that, we turn on potentially hundreds of thousands of dollars in additional recovery that's created only because this motion is granted, not because of any difference in the conduct that occurred below. I'd also add, there were several references in counsel's argument to what this would allow discriminatory actors to do. No one has been adjudicated a discriminatory actor in this case. And when these decisions are made under these statutes, these elections of going to court versus the administrative path or switching from one to the other, those are all pre-verdict. No one has adjudicated any of these cases to be a discriminatory actor. This is about the process due both the plaintiff and the defendant. We don't make any presumption that the respondent or defendant is a discriminatory actor, and therefore the respondent or the defendant should somehow be subject to the potentially prejudicial results that we'd have here. In addition to the costs of having attorney's fees added to the pile of what could be recovered, there is the duplicativeness. How does it work at trial? Do we have two summations? Do we have two opening statements? Do I have to file two bills of particulars, two sets of discovery programs? Because these two, one law firm and one government agency representing the same complaint, both want to be heard on all fronts. The civil complaint filed by the division does represent WRO. It is a stunt of semantics to say that they do not. It's the very first page on the complaint of WRO, record 115, that's in the caption. The civil complaint duplicates the administrative complaint and its characterization of the tester phone calls, page 121 to 125 of the record. And the ad damnum, the prayer for damages, seeks the same damages that WRO claims, the so-called devotion of staff, time, and resources, or frustration of mission, etc. The division seeks all of those things on this complaint. So to say that it is not representing the claim that they presented and their interests is just not sustainable. I sort of attack these things in a random order. If the court has any other questions for me, I'll answer them. Otherwise, I think I'll rest on my brief.
Thank you very much.
Thank you.
I'd like to start by addressing the point about prejudice, because respondent has argued that it would be prejudicial to have to duplicate efforts and because there are multiple parties or a proposed intervener has joined a case. That is not the type of prejudice that would bar intervention. If it were, no intervention motion would ever be granted. It is always the case when a proposed intervener is permitted to intervene that there is a new party. In this case, because of the overlap, the duplication would be minimal, and that's exactly what intervention is designed to allow. The other thing is, and this goes for fees as well, the trial court has a large degree of oversight to mitigate any of the concerns that respondent raises. So the court could limit the number of depositions, could limit the number of interrogatories that are asked, and with respect to fees as well, the fees are only awarded upon motion when a court determines that the fees were necessary, were not duplicative. And so that concern is also mitigated, and it's not the type of prejudice that should bar intervention.
Thank you.
Thank you.
Earl versus City of New York.
Good afternoon, and may it please the court. Chloe Moon on behalf of the City of New York. Supreme Court erred in denying the city's motion to dismiss and motion for summary judgment. Because the city's early intervention program consisted solely of its role in providing referrals and initial coordination, it was a governmental function and plaintiffs were required to, but failed to plead and prove a special duty here. On that threshold question of whether the city performed a governmental function, we think it's clear under Court of Appeals precedents that the city's referral and coordination services were a beneficial service meant to impact the community at large. Should I continue, Your Honor?
Go ahead, yeah.
Okay.
I'm sorry, you could wait if you'd rather me.
Whatever you prefer.
We'll start your time again. I know it's distracting.
Okay, no worries.
So we'll start again. Let me just finish
Of course.
dealing with this issue. Okay, so let's adjourn it. Okay, let me start the clock again, sorry.
No worries. Thank you so much. On the threshold question of whether the city performed a governmental function, we think it's clear under Court of Appeals precedent that the city was performing a governmental function in its referral and initial coordination of the early intervention program. I'd point this court to Terra NP, McLean, Police, all of those show where a governmental function is happening. And I'd like to point out specifically that this was a statutorily mandated role for the city. The city was not creating the IFSP. The city was not hiring or employing the providers. The city was not making reports or completing evaluations. We have all that evidence from the Assistant Commissioner for the early intervention programs from the city. So we just think this falls cleanly and neatly on the quintessentially governmental side, which is the threshold question for special duty. And then as to the Cuffey factors on special duty, as the Supreme Court found, there's no special duty here. There was no direct contact between the city, which deprives both the direct contact prong of the Cuffey factors, but also the justifiable reliance prong of the Cuffey factors. So we think for all those reasons that summary judgment should have been granted to the city and allowed, and the city should have been dismissed from this case. Unless the court has any other further questions, I'm happy to rest on my brief.
Thank you.
Thank you so much.
Good afternoon. May it please the court. My name is Andrew Harrison from Garson, Jacob, and Morris on behalf of Appellant Brownlee. I also think that the trial court's decision should be reversed. As to my client, Appellant Brownlee, we established our prima facie entitlement to summary judgment by submitting an expert affirmation from Dr. Dial Hewlett, an expert in infectious disease medicine, who opined that Ms. Brownlee adhered to the standard of care for working with immune-compromised children, and also that based on the facts in this case, she could not have been the causative factor in QD's contracting the virus that is alleged to have caused his death. This case sounds in medical malpractice, and I know it wasn't specifically pleaded that way, but as I show you in my brief with case law, in particular the Jean Paul v. Jamaica Hospital, what matters is not how a case is pled, but whether it relates to medical care or issues of medical care such that it falls outside of simple negligence. In the Jean Paul case, you had an issue with an occupational therapist who was charged with not having provided enough supervision to someone who had a sensory defect in his hand and required special supervision and ended up having a burn on his right hand because of a hot pack that was placed on his hand. Even though that case was not specifically pleaded in medical malpractice, it was determined that it was a medical malpractice case. Same as here. The allegations in this case are that Ms. Brownlee, in her role as an early interventional occupational therapist, failed to provide a heightened level of care to an immune-compromised child. That is squarely within medical malpractice. By submitting an expert affirmation, plaintiff was required to
Why
rebut
would
that.
it be, for a medical malpractice claim, you have to be rendering medical treatment that causes the injury? What medical treatment was she rendering that caused the injury?
So the case law isn't that it has to be medical treatment being provided, but that it has to relate to medical care or some medical condition. That is exactly what's at issue in this case, that QD had an immune-compromised state. It was never, so...
Right, sir, but doesn't there have to be some measure of either a supervision or a prescription by a physician for the particular services? Otherwise, there's just sort of a tangential relationship, and it really distills to common law negligence.
It really comes down to the condition of the patient or the plaintiff in the case, and whether it's care that relates to their medical condition.
Wait,
Such
what
that-
about as my colleague just stated, what about the requirement that a physician be involved somehow?
The
I mean,
Jean Paul
not
case did not
anybody
involve a
can't assert
physician.
a medical malpractice against anyone. It has to be related to medical care, and if there's no physician involved in any way, shape, or form, or medical treatment provided by a physician, how do you get into the realm of medical malpractice?
Well, there was actually medical care being provided because this patient had undergone recently a organ transplant, and there were orders in place for what needed to be done in order to
medical
protect the
treatment was
infant from being
Brownlee?
infected.
What medical treatment was Brownlee providing?
Brownlee was an occupational therapist who was providing early intervention therapy.
Yeah, I'm just a
But she's-
bit, I'm a bit confused because you just said Brownlee was a social worker. I know that there was an EI plan that was, provided, and I was under the impression that Brownlee was assisting in, the child reaching certain developmental milestones. So how does that even relate to the physical condition? I mean, I just don't see it.
Well, that falls under occupational therapy, I would argue, but I don't want to get sidetracked because the main argument is that even substantively, plaintiff did not address the contentions made by and the opinions of Dr. Hewlett. The most important one that I want to highlight to the court is that Dr. Hewlett laid out in clear detail that the HMPV virus that plaintiff was ultimately, or that the infant was ultimately diagnosed with, has an incubation period of 5 to 9 days, which means the length of time between when you're exposed to the virus and when you become symptomatic. Based on the
Your main argument, which we understand, and that's what we thought that you were going to primarily focus on, is that whether it's the March 2nd date or even assuming it's earlier date, neither of those dates fall within that incubation period, and there was nothing provided to rebut that argument.
That's correct. Yeah, there was
Okay,
no
so I'm gonna let
allegations
you-
of negligence stating from the period when he would have actually been exposed to the virus for the first time.
I'm going to let you further argue that on rebuttal, and if we need more time to
Thank you.
to do that, we will do that with you on the rebuttal time. We understand that that's your primary argument and that
Thank you, Your
no
Honor.
opposition.
Good afternoon, Your Honor. Your Honor, may it please the court. Christopher Della Carpini for the respondent.
I'm going to ask you to respond to the primary argument made by Brownlee as to that there was no rebuttal to the prima facie showing by the expert that the virus could not have been transmitted during the appropriate time frame, incubation time frame, and therefore the claim should be dismissed as against Brownlee.
Certainly, two arguments to that. Ms. Brownlee's expert relied on a chronology based on a very selective reading of the facts in the record.
Okay, so there's two possible dates even possibly out there. One is the March 2nd, and then the other one's that earlier date, which they dispute. But under either date, how do you get your client into the incubation period?
I will answer that. I do want to say that Ms. Earle did testify that Ms. Brownlee first exhibited symptoms on the 28th. But let's look at what the expert actually says. The quote from his opinion on page 1463 of the record is, "The incubation period for HMPV is usually 5 to 9 days, and individuals are generally not able to transmit the disease until they are symptomatic." That's another way of saying that sometimes the incubation period is not 5 to 9 days.
Do you submit anything, though, to contradict that opinion by the expert? There was no expert opinion introduced.
That's right.
On your side to contest that. So we have to take that as an undisputed fact, since it wasn't contested.
You can do that. And if you take what he actually said, not what Ms. Brownlee puts in her brief, but what the expert actually said, that it usually is 5 to 9 days. And
But he
generally,
opined clearly that this period could not have been the cause of exposure. He made a very clear and definitive opinion that based on the record on either of those dates, any potential illness in her part could not have been the cause of this child getting the virus. And what have you done to refute that finding? What have you provided to refute that finding or opinion?
we have offered no medical opinion to refute it, and we don't need to, because however confident the expert was in his opinion, the basis of it was an assertion that does not support it. He does not say this could not have happened, that the incubation period has to be 5 to 9 days minimum. He says usually.
That's your main argument, that it was not definitive enough, the opinion. It should have been more, expressed in a more definitive fashion?
If he wants to get summary judgment here, yes. If he wants to say it was impossible for the only person in the record who had a viral infection to have given this child a viral infection, yes, he needed to have a more clear statement of the medicine.
Could you address that the early intervention program is a government agency
Certainly.
or government function?
Certainly. Counsel was right to point out the Court of Appeals decision in Tara NP, which I'd like to quote from, where it said that a governmental function is undertaken for the protection and safety of the public pursuant to the general police powers. What did the city do here? They didn't evaluate this child for therapy. His physicians at Mount Sinai did that. They didn't evaluate the providers who were on the list. The state came up with the list. What they did was they took a referral and then they called people off the list, and when they found someone available, they set them up. That's an individual benefit. When you look at in a government, when you look at a police power that requires it becomes a government function, like in Tara NP, it's something for the public benefit. Tara NP, it was a county-run welfare to work program that we're transitioning people through. This is as individual as a referral.
Are there any cases that find that an early intervention program is not a government function?
I don't believe we cited any cases addressing the issue. But I think the Court of Appeals position in Tara is clear. This has to be pursued to the police power. This is arranging health care. This is calling up a provider. That's not a police power.
Thank you.
Just quickly on that last question, Your Honors. When you're looking at governmental and proprietary and the distinction between the two, where courts have found roles to be proprietary, it's where the government is stepping in for a private enterprise. That's landlord situations, that's medical provision, and that's not what you have here. The city is coordinating and providing that initial referral, and I just point the court to McLean, where it said specifically that city's referrals to certified daycare providers was a governmental function. Police, which said that counseling services presumed to be a governmental function. So when you look at all the Court of Appeals precedent together, it becomes clear that this statutorily mandated role that the city has is one that is governmental. And I'd just like to end on a point about the Supreme Court's kind of strange decision here. It said in the alternate for the city's argument about the government function, but that's a threshold question for special duty. So just to put a point on the fact that there's no further questions, facts to be resolved on the governmental function question. And once it is, the court has already found there's no special duty. Thank you, Your Honor.
It sounds to me like respondent's argument is that it's possible Ms. Brownlee could have exposed QD to the virus before she was symptomatic or had any reason to think she was sick, which would not be negligence. And Dr. Hewlett makes that point very clear in his affirmation. But I want to talk about the timeline, because it's not our timeline.
Well,
that
sir,
Dr. Hewlett...
1 second, please. If I understood your friend correctly, with respect to paragraph 12 of Dr. Hewlett's affidavit or affirmation, where he talks about the incubation period, I think I understood your friend to argue that Dr. Hewlett's opinion wasn't offered with the requisite degree of professional certainty, that it was a little equivocal. It used the word generally, or I think it was generally. How do you respond to that point? Because that goes to your prima facie show.
Well, he made his opinion to a reasonable degree of medical certainty. But I want to talk about the symptoms and the timing of the symptoms that are being alleged that Dr. Hewlett is basically conceding in his affirmation, okay? On February 27th, there was an intervention. Plaintiff did not have any allegation that Ms. Brownlee was sick on that date. At her 50H hearing, there was testimony about an appointment on February 28th, which respondent cites in his brief at length. There was no appointment on that date. And that, I guess the allegation that there was an appointment on that date was dropped in the motion and dropped, and actually conceded, I think, in the motion papers, because I put in my statement of material facts that there was no appointment on that date. There was no appointment on that date. There was no appointment on the 1st. The only date plaintiff has alleged Ms. Brownlee was sick or symptomatic is on March 2nd. According to plaintiff's own testimony, QD displayed symptoms on March 1st, the day before, and that symptom of coughing had progressed to wheezing on March 2nd. And Dr. Hewlett explains in his affirmation to a reasonable degree of medical certainty that it is not possible that Ms. Brownlee could have been the exposing factor to the HMPV virus based on that chronology. The QD was symptomatic before it's ever alleged Ms. Brownlee was symptomatic. That's just not how transmissions of viruses work. And that was an unrebutted opinion. And that's plaintiff's timeline, because Ms. Brownlee contests quite vehemently that she was ever sick when she saw QD and that she did not develop symptoms until 2 days after she last saw him on March 2nd. So that's with that. Unless there's any questions? No questions?
Thank you.
Thank you.
People versus Rodriguez.
Good afternoon, Your Honors. Ronald Zapata with the Office of Appellate Defender for Mr. Rodriguez. Under the warrant decision here, every law-abiding owner of a gun, every police officer, every military member, every court officer, every licensed gun owner would be subject to police entry of their home and seizure of their guns based on a mere allegation that they possess a gun inside their home. Such a search and seizure of one's home cannot be considered reasonable and therefore violates both the Fourth and Second Amendments. First, under a Second Amendment analysis, the prosecution has to show some kind of historical tradition that this kind of incursion into someone's home was done in the historical tradition of gun policies. And they have shown no such kind of historical tradition. Therefore, this is clearly a Second Amendment violation there. And then in considering it as a Fourth Amendment violation, obviously, if someone has a Fourth Amendment right to against unreasonable searches and seizures, you cannot enter someone's home based on a mere allegation of gun possession that would be unreasonable without finding out if they had a license or not first.
Counsel, isn't that the way the statute is set up, a defense to have lack of a license as opposed to an affirmative element of criminal possession? And if that's true, why would that have to be part of the prima facie presentation to get a warrant?
It has to because, well, this is exactly what the Court of Appeals in David says is an outstanding issue in the.
I'm not talking about the standing issue, though. I'm talking about on the merits.
Oh, yes, it's talking about the merits. That's what the Court of Appeals has stated, that like that has been the standard right now, but the issue there in the Court of Appeals was that the Second Amendment requires that the licensure be an element rather than a defense, but they didn't reach the issue because it wasn't preserved.
They didn't overturn this, they did not overturn that portion of the statutory scheme, which makes licensure a separate provision rather than part of the element of the offense. They didn't say that's unconstitutional, that there's anything wrong with that.
They said they didn't reach that issue because
Right,
it
so
wasn't preserved.
they didn't reach that issue, so that is currently the state of the law.
Well, no,
What's wrong with that?
Well, the state of law, though, is that no courts have decided whether, considering that statute, when you consider it in light of the Second Amendment, in light of Bruin, and now in light of the Fourth Amendment and the circumstances here, whether that can be considered constitutional. And so that's the issue of first impression before this court here now, is can licensure be considered an affirmative defense under circumstances like this, where someone can be licensed, and now this gives.
One was about the proper cause requirement for an unrestricted concealed handgun license. That's a different provision than what we're talking about here.
Yes, Your Honor. Here,
Why would that apply here?
it's about the statements it made about the Second Amendment. The Second Amendment statements are saying that someone is presumed to have a constitutional right to have a gun. In the statutory licensure law in New York for licensing at home, it's always been a shall issue state, which means it was always presumptive in New York that someone who has a gun in the home will presume to be able to have a license. And therefore, under that kind of analysis, when someone's presumed to have a gun at home, they're presumed to have it legally. And therefore, it has to be considered an element. Otherwise, this would violate the Second Amendment. And so this is the issue for suppression this court has to decide here.
Were these arguments with regard to objecting to the search warrant, or are they preserved?
Yes, Your Honor. They were preserved because defense counsel argued that there was a lack of probable cause, and it was unable to do any more specificity because the prosecution got a protective order, and therefore any of the facts presented regarding why the search warrant was presented was not provided to the defendant. As the Court of Appeals has stated this year in People v. Scott, when the defendant doesn't have an opportunity to discover the basis for an argument on appeal, then the preservation would not be required there. Here, none of the warrant materials, nothing from the hearing, and anything that the confidential informant had stated was ever presented to the defense counsel below, and therefore they never had an opportunity to present this argument about a lack of licensure. And so, unless there are, just going back to the statutory interpretation, as Judge Kern, in your decision in People v. Tatius, as you stated, it's not about whether something is a proviso or an exception. The chief concern is the statutory, the legislative intent, and about how the statute makes sense, common sense, or reasonableness with other statutes. And here, it would make absolutely no sense to allow a statute that has licensure as a defense, allowing this kind of search and seizure for someone who has a gun at home, and therefore it has to be the legislative intent for a lack of licensure to be an element of the criminal possession weapon laws. And so, unless there are any other questions, I'll save the rest of my time in rebuttal.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Russell Spivak for the People. Defendant's conviction should be affirmed. Defendant's argument on appeal about the warrant's failure to establish his lack of licensure is not preserved, speaking to the prior colloquy, and should not be reached in the interest of justice for myriad reasons, not the least of which is because lack of licensure, as the Court of Appeals stated unequivocally and with a majority just last week, is a defense and not an element of the crime, and because the warrant independently established probable cause. And finally, if this court were to conclude otherwise, remand is the only appropriate remedy. Therefore, the warrant in question established probable cause, and defendant's conviction should be upheld. I welcome the court's questions.
Any questions? Okay, thank you.
Okay. People asked what you would affirm. Thank you.
My adversary here overstates what the Court of Appeals' decision in Johnson said last week. It had nothing to do in terms of whether licensure should be an element or has to be an element. It only talked about, in terms of the merits, whether there was a facial constitutional challenge to the entire licensing scheme. And it had nothing to do in terms of this argument that was left open in David, and therefore it's essentially irrelevant to the question this court has to decide in this case. And unless there are other questions, I will rest on my brief.
Thank you.
Thanks.
Thompson versus Thompson.
Good afternoon, Your Honors. May it please the court. Mia Brill Rosenblum, representing respondent Claudine Thompson. I'd just like to step back and note that this appeal is just the latest effort in a decades-long campaign to delay appellant's obligation to support his children. The order at issue does nothing more than ensure the hearing happens so child support can finally be determined. It's an instructional order, not a final determination, giving both parties the opportunity to be heard. So the second amended order of reference is not appealable as of right, and appellant has not sought or obtained leave to appeal. This threshold issue ends the case, and this court need not reach the merits. And let me also note that appellant has made every effort to prevent the court from hearing evidence on appellant's income up through the present. Why? Because he knows his child support obligations will skyrocket if the court considers his income beyond 2018. Again, fundamentally, this case is about supporting 3 children who are now young adults whose needs have been delayed for over 6 years. Every additional delay harms them. This court can dismiss on jurisdiction alone, and it should. The trial court should be allowed to proceed with the hearing and determine child support based on appellant's imputed income, just as this court ruled when it reversed and remanded, so that it can appropriately calculate appellant's continuing child support obligation. We respectfully ask this court to dismiss the appeal and allow the trial court to complete its work. Nothing further, Your Honors.
Thank you so much.
Thank you.